Okay. Are we live now, Joe?
Only thing we don't know is if you can be heard, but
Okay, if there's anybody online, could you just give us a message in the chat to confirm that you can hear me, please?
Ewan Baxter, raised hand.
Thank you. So, good evening and welcome, everybody. My name is Murray Finch, and for my sins, I've been asked to chair this meeting tonight in a very cold and chilly Craigmere on the Isle of Mull. Before I introduce our guest this evening, I just want to give an outline of the timings. We're hoping to be finished in about 90 minutes, in an hour and a half. If anybody has questions from the floor, if you wouldn't mind just raising your hand and waiting for me to catch your eye, and then we'll give you the chance to ask your questions. If there is anybody online who's joining us has a question that they would like to put to our guest, then please put your question in the chat. And once we've had a look at it, we'll then be able to feed that into Katie in conjunction with the questions that we've already received. So I'd like to introduce Professor Katie Boyle, who is Professor of Human Rights and Social Justice at Strathclyde University. So I've asked Katie to give us an introduction to herself and her experience, but also then a more detailed summary of human rights and social justice, particularly in regards to rights of the child.
Thank you so much, Murray, and thank you all for coming along this evening. I appreciate an academic lecture on human rights might feel a little bit of a dry subject, so I am going to first of all say that everything that I discussed tonight in terms of information sharing and awareness raising and the legal framework around human rights, I've also prepared a written version of it so that people can follow up afterwards in terms of if you wanted to double check anything or revisit it. And the way that I'll speak about it tonight is, in a sense, I'll try and share with it in a sort of a story-based version rather than a lecture with slides or too much sort of the data all at once. And the follow-up information I can share in writing will have some of the specific provisions and pieces of law that I'll talk about. So I wanted to say that so that nobody feels the need to scribble any notes down, as I say to some of my students, not that they necessarily do. But the other thing I wanted to mention is when you talk about human rights, it's all, I find anyway, very helpful to just reflect on what are very common understandings of concepts like dignity, and in the case of children, one of the overriding principles of international human rights is meeting the best interests of the child. And obviously all children are different, and so that requires different types of responses, but the best interests is a helpful way of reflecting about children, and dignity is this overriding concept that applies to all human rights. And it's a really helpful way to think about it because it's something that resonates with most of us anyway, and actually in the realisation of rights, whilst you can have people who have expertise in legal frameworks or expertise in a kind of social science related or evidence-based approaches to what different rights mean, the people who are the greatest experts in the realisation of rights are normally the people themselves who hold them and the communities themselves. So the expertise that's lived is the most important in terms of understanding how to better realise rights, and listening to that expertise is key to rights fulfilment. So in terms of my background, so I'll start with an introduction to my own areas of work and my research, and then I'll speak a little bit then about the legal framework for human rights. So my overall objective for this evening is to share with you the legal frameworks and information and knowledge and the language of human rights, so that you are familiar with that when you are thinking about anything which might connect to human rights violations. So it's an exercise in trying to empower in terms of having that knowledge and me passing that on. So my expertise isn't in the lived experience, it isn't in the day-to-day realisation, it isn't in what is happening in any one place at one time. It's on the legal framework itself. So I'm sharing that with you in a way that I hope can be as accessible as possible, so you have those tools within your toolbox. The next thing that I'm going to do is then talk about some of how that operates in practice in Scotland. So very much, this is the human rights legal framework, and this is how human rights operate in practice within a Scottish context, so that everyone is on the same page in sense of the legal framework and what's required of it. So by way of background, I initially qualified as a solicitor with the Government Legal Service in Scotland, so I primarily specialised in constitutional law and human rights. And then I completed a PhD in Ireland on economic, social and cultural rights. So those rights are the rights that relate to things like housing, health, social security, education, an adequate standard of living. So those kind of everyday rights for an everyday life of dignity are what I've specialised in from when I first started working in academia. That coincided, luckily for me, with a really amazing opportunity, because in the UK, there has been, in a sense, at the national level, a somewhat reluctance to fully engage with the UK's international obligation in human rights law. But in Scotland specifically, the Scottish Government, since around 2015, has committed to better protecting international human rights law within Scotland. So there's been a trajectory of at least a commitment to further legislation to help better protect rights. And I'll speak a little bit about what that means, but because I had specialised in international human rights and economic, social and cultural rights specifically, I was asked to join different advisory groups, help, for example, the government in terms of their advisory group, but also the Children's Commissioner around UNCRC incorporation, which is the UN Convention on the Rights of the Child, which I'll speak a bit more about soon. And also, there's been basically similar movements in other devolved parts of the UK. So I also advise the Northern Ireland Children's Commissioner on UNCRC incorporation there. And then there's similar movements in Wales where there's been a move to better protect rights. So you see these like really unusual, from a legal perspective, very interesting thing happening, where at devolved level you have a move towards international law and better protecting rights. And as research has told us for some time, quite an aggressive trajectory at the international level at the national level in the UK of pulling back from rights protection. So that's an interesting dynamic in and of itself, because the wins that have been gained in terms of better rights protection should create a difference in those devolved frameworks, because there is more rights and more law to rely upon. So some of my work has been around the better protection of rights via these advisory roles, and then I do broader research on what I would call problems that are collective in nature, so forms of systemic injustice. So I look at systemic injustice in different countries, in different situations, where normally what you'll see is, especially with economic, social and cultural rights, a violation that happens to one person is probably happening to a lot of people. So it becomes systemic in nature, but quite often what legal systems do is require people to respond on an individual basis. So you have almost like a conveyor belt of injustice, or what I would say, you have collective injustice becomes individualised. And that's really disempowering, because when you look at the research around movements where social injustice exists, normally the greatest successes are when people are able to pull together collectively. And collective forms of redress are normally the most successful. And what's particularly interesting for me is when you look at rural communities and island communities, and like I say, I can't speak on behalf of your lived experience, but what I witness when I come here is the warm welcome, of course, but this incredible sense of community, incredible sense of resilience, of working together, and the cohesion that that brings when you have that collective aims and objectives. And so in some of the research that I've undertaken in other places, you see, by way of example, regardless of what happens in terms of legal routes or judicial proceedings, normally when people are collective in their struggle together, you still gain wins regardless of what happens through other avenues, because you create an environment where symbolic, material or substantive change becomes inevitable when a situation that represents an injustice becomes untenable. And that happens across my areas of work. In terms of human rights, the aim of human rights itself is often thought of as a tool for rights holders, of which it is, of course. But ultimately, human rights as a legal framework is also a tool for decision makers. And you will see often on frontline services, people will be put in really difficult situations where they have to weigh up different rights and also other pressing needs, including economic and financial ones. And so decision makers themselves that can draw on human rights framework basically have this toolkit at their disposal to say, we're supposed to do these things in order to make sure that we are doing our best to provide dignity, to provide for the best interests of the child, to meet people's needs in a way which is human rights compliant. And we have a roadmap for that. So sometimes for decision makers, one of the most important things is if they feel in a position where they are not able to meet statutory obligations, they have to also be able to bring in the other duty bearers through which human rights realisation is made to say we need to work together in order to do that. And that's another thing that we see in the research. That space is sometimes missing because there's a complicated collection of people who are responsible for different things in law. Law is messy, it's constructed by humans, it's socially constructed, we don't get it right, there's no panacea, and human rights are not perfect either. So social injustice is often a struggle where you've got to constantly try and build upon what you can, using what tools you can, and that includes for decision makers themselves at all levels. So in terms of the human rights framework for law in Scotland, we have to start with what I mentioned before, which is that we have essentially the UK, which is the state party to international treaties. So the entire human rights framework came out of the back of the Second World War, 1948. Countries around the world agreed this should never happen again. Dignity is at the heart of that, and we have the Universal Declaration of Human Rights in 1948. I like to think of human rights as a little bit like a tree. So the UDHR, the Universal Declaration of Human Rights, this is the trunk of the tree, and all treaties that connect to human rights came from this trunk. So at the international level, following the Universal Declaration of Human Rights, we had a number of other treaties. So in 1951, we had the European Convention of Human Rights, and that's the treaty which covers human rights within the Council of Europe. And the Council of Europe has 46 member states, so it's separate to the European Union. But that treaty became integral to the UK. We don't have a codified written constitution like other countries, so our human rights framework is actually directly derived from the European Convention of Human Rights, and that is incorporated or domestically brought into our law via the Human Rights Act and the Scotland Act in Scotland. So anything that contravenes the ECHR, the European Convention of Human Rights, within the UK is unlawful. It sets a standard, it's our constitutional framework for rights realisation, and that's an important treaty to be aware of because it applies to all of us whenever we engage with the state in any shape or form. After the European Convention of Human Rights, we had on the branches of the tree a number of other treaties. So shortly after the Universal Declaration of Human Rights, the UN committed to saying, well, we need to expand on that and really give people a sense of what we mean. So we had the Convention on the Elimination of Racial Discrimination. Then we had the Covenant on Economic, Social and Cultural Rights, which is the area I specialise in. We had this Covenant on Civil and Political Rights. So they're around about 1966, 1967. And then after that, we see a number of other treaties. So the Convention on Elimination of Discrimination Against Women, shorthand is called CEDAW. That treaty came in sometime later, eventually leading to the treaty that embeds children's rights. So the UN Convention on the Rights of the Child dates from the end of the 80s and became law, or was incorporated into, it was signed and ratified by the UK in 1991. So as a matter of international law, the UK has obligations under the UN Convention of the Rights of the Child since that date. So all of those treaties that I mentioned, the UK is the state party and has been historically at the forefront of rights realisation on the international scene, played an important role in the European Convention of Human Rights. 2 Scottish lawyers are in the preparatory work to that treaty that come up with part of the draft. It reflects our kind of principles and values. And eventually we have this UN Convention of the Rights of the Child. Now, apart from the Human Rights Act and the Scotland Act, which bring that European treaty into domestic law, we don't have any other incorporating acts. So the UK, as a state, has responsibility for all these international obligations, but hasn't taken what is called the second step, because it is what's called a dual estate, to bring those international obligations into our domestic law. And that means even although they exist in international law, and there are some complaints mechanisms at that level, such as in relation to disabled rights, we don't actually have the legislation at the domestic level to get remedies. So I call that the UK accountability gap. So the UK signed up to these obligations. It says, for example, everyone should have the right to adequate housing, everyone should have the right to social security, to an adequate standard of living, but it doesn't necessarily provide the legal remedy should something with those rights go wrong. And I should mention that when you talk about these rights, as with the rights of the child, they are not absolute in nature. That allows for some limitation on the rights when you're trying to balance things out in a democratic society, but you have to be able to demonstrate that you're doing that in a fair way. It has to be necessary, legitimate, proportionate, fair, no alternative available, and those tests are there to help us with that. So in relation to children's rights, some of the key provisions around that are that Article 12 of the UNCRC tells us that children should have the opportunity to have their views heard. And that means not in a tokenistic sense. It means when any decisions are made that impact their lives, they should have a substantive opportunity to engage in a process in a way which means genuine, inclusive and participative decision making. Article 12 is a really important mechanism for children. Article 27 is the right to adequate standard of living, which includes the right to adequate housing. Articles 28 and 29 are the right to education, and not only the right to education, but the right to education that actually meets the developmental needs of children in a way that allows them to flourish in their full potential. And that's the standards that set the developmental needs of the child to their fullest potential is Article 28 and 29. And then Article 31 is the right to cultural life. So this idea that you create an environment and foster culture and cultural heritage and a cultural environment, participation in sports, everything that will enable children to flourish in their everyday life. So the UK accountability gap is the big space in which we can't rely on these rights in domestic law. But the Scottish Parliament stepped in following this commitment over 10 years now, where the Scottish Government has said as part of its manifesto repeatedly, we are committed to these international norms and standards. We will close this accountability gap domestically. We will introduce these treaties into Scots law in a way that enables compliance in devolved areas. So We have in 2024 a new act which is called the UNCRC, or United Nations Convention on the Rights of the Child Incorporation Scotland Act. Now that act was subject to challenge before it was passed by the UK government that felt uncomfortable about whether or not the Scottish Parliament had passed the legislation within its devolved competence. It's important to say that when it was passed initially, the bill was passed unanimously. Every party supported it. There was no dissent to saying, yes, we agree children's rights should be part of our law. The challenge went to the Supreme Court, and the Supreme Court said it's absolutely within the power of the Scottish Parliament to incorporate international treaties, including the UNCRC, into domestic law, but it can only do so in relation to
the UK Supreme Court.
Yes, this is the UK Supreme Court, so the highest civil court in the UK. So the UK Supreme Court has said, yes, that's fine, the Scottish Parliament have that power, but only in relation to areas of devolved competence. And then they went a little bit further than devolution had operated prior to this judgment and said, and by that we mean the UNCRC can apply in relation to acts of the Scottish Parliament so long as it doesn't interfere with the unqualified power of the UK Parliament. So unqualified power was the language they used. Now, the way that was interpreted in Scotland by the government was, okay, we'll reintroduce the legislation, but what we'll say is the UNCRC as a treaty now becomes law in relation to all public acts or any public functions which are conferred on any duty bearer in Scotland, whether that be government ministers, whether it be public authorities, local authorities, councils, or private bodies that are exercising public functions, because a lot of public functions are now provided via outsourcing, by way of example. So the UNCRC applies, but only in relation to acts of the Scottish Parliament. If an act of the Scottish Parliament happens to amend an old piece of UK legislation, we can't apply the UN Convention of the Rights of the Child to that old piece of legislation. So by way of example, the Children's Scotland Act is an older act, and a lot of what the Scottish Parliament has done is amend that old UK Act in order to update the law. And sadly, that means, by way of kind of historical happen chance, that none of those acts are covered, but there are acts that are covered. So there are many acts of the Scottish Parliament which confer powers on public authorities and other duty bearers that fall within the scope of the UN Convention on the Rights of the Child Act, which means not only does the ECHR apply, which is the European Convention of Human Rights, but so too does the UNCRC. The way that the Act became law was that the Parliament went back and revised the initial bill and made these changes so that it was in compliance with the Supreme judgment. So that gives a flavour, and I very much appreciate whistle-stop tour of a lot of complicated stuff. It's not just, it is complex to everyone. So this means that not only is this law new, so when you look at, for example, Article 12 of the UNCRC and whether or not children should be able to have their views heard and express their views, or Article 27 on an adequate standard of living, these are new provisions in law, and they bring in international law, which is new to many, including the legal world. It's new forms of rights, and then you have this complexity around, we have the Supreme Court judgment and it only applies in certain circumstances, but there are circumstances in which it does apply, and so it's important to be aware of the examples where it does apply. So, for example, Consultation Schools Act, it applies to that. It's an act of the Scottish Parliament. It applies to the Standards in Scotland Schools Act. So you have acts which are caught and which UNCRC does apply, and they're important to be aware of. So that kind of gives you a sense of where the legal framework is. When I mention about the balancing of rights, which is difficult, is that not all human rights are absolute in nature. So I'll give you an example of one that is absolute in nature, and then an example of one that's not. So Article 3 of the European Convention of the Human Rights says that no one should be tortured. There is no circumstances in which you can interfere with that right in a legitimate way. It's an absolute and what's called a non-derogable right. It means that everyone should be protected from any form of torture, and it's a really important benchmark below which no one's allowed to fall below. So that's an absolute right. On the other hand, you could, for example, look at Article 8 of the ECHR, which is the right to private and family life. That is not absolute in nature. So while it exists that people should absolutely, to the fullest potential, be able to enjoy their private and family life, sometimes interference can be justified with that right, but only in certain circumstances. So in order for interference to be legitimately justified, you need to demonstrate the following test. It needs to be necessary, in accordance with the law, proportionate, and no other possible alternative was available in order to achieve a legitimate aim. And you would expect when any interference of that type of right occurs that you would have an explanation of how that interference is in compliance with those rules. So it must be necessary to achieve a legitimate aim, proportionate, and no other alternative available. Things like arbitrary or blanket policies tend never to meet that because they haven't looked at the nuance of how rights realisation should be managed. In relation to some of the other rights I mentioned, such as the right to adequate standard of living, so that includes the right to adequate housing, the right to the highest attainable standard of health, the right to protection of family in terms of social security, or Articles 28 and 29 of the UNCRC, which are all about education, or 31 in relation to cultural life. There's additional requirements for those tests. And this is the part that's new in Scotland. So there's learning for everybody in this sense, in every walk of life, including people who have been experts in human rights for a long time, because it is new types of law that we're dealing with. So when you have, for example, any of those rights, again, you can have legitimate interference, but you need to demonstrate as a duty bearer that you have taken certain steps. So the steps that you have to do are continuous steps to try and progressively achieve those rights, that you must take steps to respect them, protect them, and fulfil them. You must gather adequate resources in order to realise those rights, and when resources are in place, you must spend them in a way that is effective, efficient, adequate, and equitable. You must ensure that you do not have discrimination. There should be no discrimination in the realisation of rights. There should be no retrogressive steps, so there must be no backsliding in their protection. Any interference needs to meet the same tests around legality, legitimacy, and proportionality. And proportionality is really important because that is the place in which you say, well, in this circumstance, the impact would be this. But if we balance that out over here, we're going to end up with this result. So in the overall proportionality assessment, the fairest way to do this in meeting everybody's needs is to take this route. And that applies to everyone. And that's a constant balancing exercise. And finally, the thing that's required of these new rights is that we should have effective remedies available. And remedies can be provided through many different routes. And I can speak a little bit about different options that relate to children's rights under the UNCRC Act. But I'm aware that I've spoken for quite a long time now, so I wonder, is it a good opportunity to take a pause and also offer to speak about how those cases tend to operate in practice, any examples of cases in Scotland, the UK or elsewhere, and whether or not it's helpful to know about other countries. But I do want to just mention very briefly at the end what the Scottish Parliament did in embedding these rights. Unanimously, all parties got behind it. All parties said every duty bearer needs to comply with these rights in exercise of the public functions that are caught by the Act. We are not the first country to do this. This is not novel in the sense that no one's ever done this before. Countries all around the world embed human rights. Countries all around the world have constitutional rights. Some of them embed international law domestically. Norway and Sweden both incorporate the UNCRC. We have countries which have really advanced litigation systems around these rights, really advanced understandings of how they work in practice. And one example that I always revert to as an example of what it's like to have them and what it's not is in South Africa post-apartheid. The children's rights were embedded in the constitution, along with other rights, including economic, social and cultural rights. And during COVID, when we had the closure of schools, many free meals were stopped for children all around the globe when you didn't have access to education. And I don't know if you remember, but in the UK, it was a big part of even parliamentary debate, and we had the footballer Marcus Rashford who ran the big campaign around that, and people really got behind how outrageous it was. But we didn't have domestic law in which children's rights were protected, so we relied on this campaign by someone who decided, like, this is outrageous, I'm going to do it. In South Africa, similar circumstances arose. A case was taken to the Constitutional Court. Constitutional Court looked at it and said, this is a retrogressive step, it's backsliding, just those rules that I spoke about earlier. That means it's unconstitutional, it's therefore unlawful. Reintroduce the free school meals programme and make sure these 9 million children get access to food. And that, to me, is the difference. But these are new things to learn in terms of how we go about that. And there's so much rich literature and rich practice in terms of understanding how to do that in practice. But we are all the better for it if we work together in terms of what we do collectively recognise as important aims, which are about ensuring dignity and human rights. And in particular in relation to children, letting them realise their fullest potential. Thank you.
Thank you, Katie. That was a very long 10 minutes. But to be honest, it was fascinating, and I just wish that I could write in shorthand because it's prompted lots of questions for me. But before we go on, do you want to just mention that? I'm
very happy to do so. Yeah, do you want me to just read it out?
Yeah.
So, of course, we have to be aware that there is a pending judgment for a judicial review in connection with some of issues in relation to in relation to economic, social and cultural rights and the right to education in Mull. So whilst that judgment is pending, we're also constrained by the Contempt of Court Act, which has a strict liability rule about public discussion or broadcast of legal proceedings before they're included. So I'm very happy to speak about any legal proceedings once they're concluded, but not before. So what I'm here to do is information sharing, awareness raising, and very happy to talk about the human rights legal framework as it applies in Scotland and in the UK and how it applies comparatively. And that's just to give you a sense of also managing the legal constraints in terms of how we take discussions forward.
Thank you. So we've got quite a few questions which have been submitted in advance, and I'm going to read those out and then hope that Katie can pick them up, provide some answers, and there may be a little bit of to and fro between us as those answers come back. And I can see that we have one question online as well, which I will try to bring in at an appropriate point in the next few minutes. So the first question is, under the UNCRC incorporation in brackets Scotland Act 2024, who is the primary duty bearer? Who is the primary duty bearer responsible for ensuring children's rights are met in local education decisions? The local authority, the Scottish ministers, or both?
Do you want me to go ahead with that? Yeah. It's a really excellent question. So under the UNCRC Incorporation Scotland Act, Section 6 of that Act says essentially that any public authority is a duty bearer under the terms of the Act. Now, I mentioned earlier that the Act is limited in scope. So when functions are exercised under an act that is not within scope, those public authorities, whoever they are, wouldn't be required to comply, but there would be nothing prohibiting them from complying unless a UK Act of Parliament compelled them to do otherwise, because these are international obligations. So it would be good practice for all public bodies under the Human Rights Act, the Scotland Act, and the UNCRC Incorporation Scotland Act to be mindful of international human rights obligations when complying with human rights anyway, because all of the treaties read together help us to understand what those rights mean, and there's different bodies that oversee compliance with different treaties who provide further guidance on it. So one of the things that the Human Rights Council, which is the UN Council responsible for overseeing the Covenant on Civil and Political Rights, as well as human rights more broadly, has said that sometimes it can be really confusing when you are implementing rights as it sort of falls down a trail between the state, which is the primary duty bearer. So the UK state is the party to the treaty, and it's, as a state, agreed to be bound by the treaty itself. So it's the primary duty bearer, but it will delegate responsibility to other bodies all of the time. That's what happens in statutes. That's what happens when government is acting on behalf of the state. So in that sense, the easier way to think about who's the primary duty bearer is if you are exercising a form of public power, you are most likely a duty bearer. If you are making decisions on behalf of the state, you are a duty bearer. So Section 6 reflects a similar provision in the Human Rights Act, which is to say that anyone performing public functions is required to comply. So all duty bearers, and that goes all the way from local decisions right up to government ministers, all the way. So what's difficult about that is, well, who do you go to when you think something has gone wrong? And really, when you look at a statutory function, so a function or a power is normally delegated somewhere, and it's normally delegated within legislation itself. So that would be a good place to start. So the primary or the local decision, wherever that may be, but ultimately none of the other decision makers higher up that chain can absolve themselves from that responsibility. So the state always retains responsibility. And there's a really good example I was looking at recently. So one of the big cases in Scotland around human rights is a decision called Napier v Scottish Ministers, and it's from way back in sort of 2005 through 2007, where there was a prisoner in a Scottish prison who had bad eczema and took a case against the Scottish ministers because, as part of his conditions of confinement, he had to slop out, which meant he had to dispose of his toilet waste without access to a toilet, which worsened his conditions. And the court found that that was a violation of Article 3. So this one about inhumane and degrading treatment and freedom from torture. So in that case, that particular person who was subject to those conditions took the case against the Scottish ministers. And in that case, the Scottish ministers said, well, actually, it's the prison authority that has a responsibility. And the court said, you can't absolve yourself from that responsibility too. But that was in an interpretation of the Scotland Act in which Section 57 of that Act confers responsibility to the Scottish ministers in relation to public administration. So there will always be complications about who is responsible, but think about it as a chain of command that it goes both up and down. And as a result of that, local decision makers should also think of human rights framework, including the Human Rights Act, the Scotland Act and the UNCRC Act, as a tool of empowerment for them, because if they're not able to meet statutory human rights obligations, then they need to go further up the chain to say, we are not meeting the obligations that you've conferred on us, or we are finding it difficult for these reasons because we are constrained. We need to get together and help. And the Human Rights Council at the UN mentioned this. They said duty bearers need to get together and sort problems out. We can't just keep passing it back and forward. This is a known problem, but also that means demonstrating that you can do that would be globally excellent practice. It would be referred to as excellent practice. It's an opportunity to demonstrate excellent practice.
Yeah, thank you. You've answered the question, but I still feel that there is a difficulty. And one of the phrases you used in your introduction was accountability gap.
Mm-hmm.
And I sense that there is an accountability gap between Scottish Government and local authority, where each looks at the other and says, it's your fault, and they just point fingers back at each other. Or, perhaps even worse, they deny that there is a fault at all. So if they are unsure, or if they are ignorant of the fact that a breach of children's rights has occurred, they may not feel the need to push back onto the other authority. So you just mentioned there that it is very complex. Is there any way to cut through that complexity, do you think?
Yeah, I mean, I do think of it as an accountability gap. So, and as I mentioned, the government has for some time committed to addressing that, and credit where it's due, there has been change that the Scottish Parliament has led on, which is novel, ambitious, and is globally really, in fact, that UNCRC incorporation Act was referred to by a previous member of the UN Committee on the Rights of the Child as probably the best piece of legislation for children's rights globally. So credit where credit is due in terms of being ambitious and forward thinking around that. One of the mechanisms through which rights realisation has to happen, so in addition to the UNCRC Act, the government has also committed to a human rights bill which incorporates the other treaties, so to close the gap in relation to those other ones I mentioned, like for not only for children's rights but for elimination of racial discrimination in terms of equality for women, in terms of economic, social and cultural rights, the Convention on the Rights of Persons with Disabilities. And when looking at how to manage that accountability framework, the way that it's spoken about, and a lot of my research has been part of looking at this, when you look at how states manage to do it, they have to recognise the fact that accountability only works if it's multi-institutional. So a multi-institutional accountability framework has to open up lines of communication across the board. So normally in a state, what you see is three arms. You have the Parliament, you have your legislature, you have the court, or the judiciary, and you have the executive, and each is responsible for holding the other to the account. So the Parliament is responsible for holding the government to account, and the executive, and the courts are responsible for holding other branches to account, and back and forth. So in countries that have broadened out there or really investigated how to do this well, what you see is multi-institutional accountability, where you have the Parliament, you have the court, you have the executive and all of public administration. Then you also have regulators, inspectorates, ombudsmen, and anyone through which accountability where accountability can happen is responsible for helping the others to meet their obligations. And the best way that will happen is when you open up communication channels in which to realise that it's shared responsibility, and it's required in difficult circumstances. And in part of that new framework, alongside that concept of multi-institutional accountability, is the idea that when you have a challenge, when there is a problem or a violation, normally there will be multiple people responsible. And so the only way to fix it is to have a structural response in which we require multiple agencies or a multi-agency framework to respond to that. So that's called structural remedies. They're used all over the world. as a way of trying to address human rights violations, and they're more proactive in saying, right, okay, this person needs to do that, body needs to do this body needs to do that. So we're in the early days of understanding how that can work, but an aggregate approach where you have different actors doing different things is required, and it's the responsibility of all of them to open up those communication channels to achieve it.
Oh dear. Okay, the next question that I've got is another of the advanced questions, and you've just touched on it a little bit there with the mention of the judiciary. So this second question is there any independent oversight mechanism in Scotland that can assess whether a local authority's decision is compatible with children's rights, short of a judicial review?
So I think of, I mean, there's lots of things going on there, because for impact assessments are one thing. So and it's important to note the difference about this, because sometimes there can be confusion. So an impact assessment is something I like to call a procedural duty. It's a right to a process that, and it should be a fair and proper process, and it should be genuinely inclusive and participative. But ultimately, impact assessments don't necessarily require a particular substantive outcome. Whereas human rights as standalone rights and compliance with human rights, which is what the UNCRC and the Human Rights Act and the Scotland Act require, compliance is more than an impact assessment. It will most likely include an impact assessment, but then it will take a step further to say, and this is how we are ensuring we actually achieve those rights. So that is a substantive duty or an outcome-based duty, and those are different. So you're not solely reliant on impact assessments having occurred. Human rights compliance is a continuous obligation all of the time. It applies to acts or omissions. So sometimes the challenge or the violation might be someone not having done anything. So it's like a continuous obligation, not solely connected to that assessment. In terms of oversight, there are multiple routes you can use for human rights compliance or in relation to either procedural or substantive duties. Typically, you would expect, so if you think about human rights compliance, the court has to be there as the accountability mechanism, and ideally in society it should be the one of last resort. So you would hope that other mechanisms would work to resolve issues sooner, but it is an important backstop, and it is absolutely critical to human rights realisation and to compliance with all statutory obligation and common law rights. You also have other routes which are non-judicial, but even in relation to court itself, in the UNCRC Act, UNCRC can be relied upon in any court or civil proceedings, including sheriff courts, tribunals. So it can be any action. It could be any action in which there's a rights issue that comes to the fore. Under the Scotland Act, any action which requires resolution of what is called a devolution issue, which can include human rights, can streamline cases into higher courts in order to be resolved. But we also have opportunities not only in courts or tribunals, but in other mechanisms like the Scottish Public Service Ombudsman, which also hears cases and can help try to resolve difficulties. Other routes to remedy could include local complaints mechanisms. So in my research, when you look at this, I study what's called the right to an effective remedy, and I look at whether or not these routes are actually effective in nature. And so many of them aren't, because ultimately they can't actually deliver an outcome that will change the violation itself. So that's difficult, because we have to recognise that there are limitations in these different routes. But that is what social injustice and the struggle for access to justice is. It isn't a perfect system. So these routes, so important to be aware of them. So the way I try and think about access to effective remedies is use every avenue at your disposal, try every possible means of trying to achieve the aim of rights realisation and lean into those different opportunities as much as you can, including trying to resolve through all different types of alternative mechanisms. But there isn't a separate court that deals just with human rights or just with children's rights. The idea is that UNCRC and children's rights and human rights can be engaged in any proceedings that come before any court. So in the ideal sense, they should be available to be relied upon.
Yeah, a lot to take in. Thank you. I'm going to skip one of the questions that came in advance, and I've got a different question that I want to incorporate with a supplementary from online. So the short question, is affordability or unaffordability an acceptable justification for ignoring the rights of our children?
So we have these rules around the tests that you have to comply with, or to demonstrate that you've met when you comply with rights. So under the ECHR, those tests are that it's necessary, that that your action which interferes or breaches rights in a sense with interfering with someone's rights, that it's necessary, that there was no alternative available, that it was legitimate, and that it was proportionate. So affordability is one of the reasons when you have, for example, a legitimate aim of trying to balance rights in a democratic society, and that's a well-versed one. But affordability also needs to be couched in a reasonable sense. So you have to assess that using tests of reasonableness. So in the ECHR jurisprudence, what you'll see is that that you would have to demonstrate that it was manifestly without reasonable foundation to act in a particular way, including that in the overall balancing of rights and affordability, that all actions were taken to try and address that. But we will constantly, it's totally understandable and really important to address this scepticism about rights realisation, which includes we don't have money to provide everybody's rights all of the time. And the rights framework recognises that. It doesn't say that that's what's supposed to happen, because what you could end up happening is you've got complex, or what's called polycentric, so it's when you have lots of different policies that all conflict with each other and one takes from the other. So you need to be able to ensure or feel confident that you've taken the steps to measure what you're doing in a way and to balance it out. But in addition, as I mentioned, when you look at economic, social and cultural rights, there's more tests, and actually it gives us more guidance on this. So it says you need to gather the maximum available resources, which can include being quite innovative. It's not just about money itself, it's understanding other resources, which includes
the community.
Yeah, and people performing different, so human resources as well as financial resources, as well as institutional resources, as well as local resources. So you have to gather the maximum available resources, and then the test is you need to ensure that when you have resources, you spend them in a way that is effective, efficient, adequate, and equitable. So these are new rules under this framework, but they give certain standards about.
Just remind us, from when are they new?
Since 2024. Okay. So that under that UNCRC Incorporation Scotland Act, things like the right to adequate housing, the right to education, the right to social security, all of these, right to cultural life, these are what are termed economic, social and cultural rights. So you have these added requirements. You have to take steps, you have to raise the maximum available resources, you have to spend money in effective, efficient, adequate and equitable ways, you have to ensure non-discrimination, non-retrogression, and ensure access to effective remedies. And there's also a requirement to ensure the minimum core of rights, which is think of as like a overall requirement to meet a standard of dignity for everyone that no one should fall below. So that minimum core applies as well. So affordability can be part of the balancing exercise, but not to contravene rights without having demonstrated you met all of those tests, and you would expect decision making to go through those tests, in particular when making decisions about resource allocation affecting children.
And that brings us very nicely onto the supplementary, which Katie hadn't seen in advance. How should local authorities demonstrate that they have properly considered the rights of the child? How should local authorities demonstrate that they have properly considered the rights of the child when financial pressures might be cited as a reason for delaying education investment?
So I'll speak about that in a broad sense rather than in relation to purely any specific right. So public authority. So there's several different things that the UNCRC Act requires. One is, for example, the preparing reports and preparing child rights schemes, which duty bearers are under a requirement, including local authorities, in order to demonstrate how they've thought about it at a systematic level, how they're going to realise rights. This comes with a caveat, of course, that I am talking about rights compliance under the UNCRC in relation to those acts that are within scope. So you've got that complication of some of the UK acts being out with scope, but also that because they're international obligations, there's nothing to stop public authorities meeting those international obligations unless they're compelled not to do so. When affordability comes into the question, as I said, you still have to meet those other tests. But in relation to, I think the question was about how do you ensure proper consideration of the rights of the child. So the treaty itself tells us, so it says you have to listen to the children. And that has to be in a way which is genuine, inclusive, participatory, in a way that is appropriate for them. There's actually a standard that's been developed which is used globally. It's called the Lundy model, and it's based on a professor at Queen's University, Laura Lundy, and she developed a participation model for children's rights. So you can look at the Lundy model and you can go, did that happen, yes or no, and then you'll have an idea of whether or not Article 12 has been met in relation to properly considering the rights of the child by listening to their views in the first place. And then in relation to significant decisions, you would expect to see decision makers willing to share the reasons behind why decisions are made in a particular way, and taking into account those requirements. And also bearing in mind that, people who work in public service have complicated decisions to make all of the time, and they're supposed to have an infrastructure around them which help them to do this. And it's unfair to place that obligation, say, on one or two people. And if one or two people are left with that obligation, they need to raise it up to their senior management to say, we need to make sure that we have the infrastructure around us to be able to do this properly. And that's a constant, negotiation that, as I say, up and down that chain of commands to make sure that duty bearers have the resources to demonstrate compliance with rights, and that they do it in a way which is child friendly, which includes that participation element.
Okay. I don't think I've ever heard of the Lundy model.
Yes, she's fantastic.
Anybody else? No, I don't think we've come across that, which is quite interesting, quite telling. So I'm going to go back to one of the original advanced questions, and until this evening I don't think I'd heard the phrase progressive realisation, but you've used it several times this evening. So what does progressive realisation of children's rights mean in a small rural or island community? What does progressive realisation of children's rights mean in a small rural or island community, and how should authorities demonstrate that conditions have improved across generations rather than simply become normalised?
I think that's a really excellent question that draws upon a number of different issues. So progressive realisation, that term comes from the International Covenant on Economic, Social and Cultural Rights, and that's the parent treaty of economic, social and cultural rights. So the other treaties, like for women, for disabled persons, for children, draw on the understanding from that treaty. So the treaties are all interconnected in a way. So in the International Covenant on Economic, Social and Cultural Rights, in Article 2.1, it says states are required to progressively achieve the rights in this covenant. And then it includes things like education, social security, housing, and so on. I mean, an adequate standard of living. So it touches everything from access to water, access to food, adequate provision of things. I always find and it's important to note this, the rural communities and island communities, because you do see parallels at times between communities that operate in these types of spaces have for so long worked so closely together in order to create the infrastructure to live cohesively. And you'll see this, for example, in Indigenous communities in different parts of the world, that often, this is just as a sort of a side point, often what you'll see is rather than look at rights as state down, what communities want is the chance to do it their own way, because they tend to have the knowledge to know how best to achieve it. And so as an important part of that, progressive realisation needs to listen, first of all, to understand the particular dynamics, and to share power in a way that enables communities to ensure progressive realisation. That means continuous improvement. You can at times see that states will say, look, there's an economic downturn just now, we can't achieve the progressive realisation we'd hope for, and in those circumstances you can justify temporary measures which mean continuous improvement isn't possible. And in relation to the UK signed up to this concept of progressive realisation since the 60s. It has to report periodically every 6 to 7 years to the UN on how it's doing it. So that's the UK state party that does that. The Scottish Government contributes to those reports and says, so for example, the UNCRC Incorporation Scotland Act is named across multiple UN committee bodies because the UK government, as well as the Scottish government, say this is an example of progressive realisation, this is an example of rights realisation, and then it's used as an example globally to say we're actually doing really well in this regard. So progressive realisation is a requirement over time. So from the 60s, you've got that duty in place. From 1989, that is when the UNCRC comes on the table, and from 1991 the UK's agreed to be bound by it. So it should be thinking about this as a continuous requirement over time. What we haven't had is domestic remedies for enforcing it until recently, and what you would expect to see is many different forms of systemic and structural injustice should be addressed. And what you see in Scotland, this is just again something of interest more broadly. We see commitments about things like ensuring that we don't have areas decline, ensuring commitments to ensure that we don't have depopulation. So on the one hand, we have policies which appear as progressive realisation and trying to shake off the legacy of historical injustices and around issues like land reform and so on. And that should be matched with a commitment around also ensuring the constant continuous improvement of rights realisation, and that requires understanding lived experience in those communities. So the Scottish Human Rights Commission produced a report either last year or the year before, which demonstrated that rural communities in Scotland and the Highlands and Islands they looked at specifically are have a number of significant systemic human rights breaches in relation to things like, by way of example, access to healthcare, access to adequate education provision, and so on. So there's a greater awareness that there's been a gap, and a need to shine a clearer light on some of these. And the fact that island communities and rural communities have built such resilience doesn't mean that states or anyone exercising public power or public authority can rely on that resilience as a backstop. Those obligations exist regardless. And the fact that you have such great resilience and cohesion and community is a testament to those communities, and it's amazing to see in practice, and really that's an opportunity in which to work with communities to progressively change over time, and that's in relation to lots of historical issues that have arisen and are coming to light.
Thank you. So I just scribbled a couple of thoughts down there as you were explaining that. How is progressive realisation measured by governments? Is it based on intent through legislation that is passed, that is supposed to deliver it, or is it based on results? In other words, subjective information perhaps gained through the 10-year census or the 2-year census.
Yeah, it's excellent. So I actually was just also taking a note when I finished answering that about the evidence base to demonstrate it. So at the international level, the UN's developed indicators and an evidence base which any state can use to help them understand how to demonstrate that evidence. So one of the most important things that's needed in order to achieve that is you need to have data to understand the different requirements of any community, and then you need to disaggregate that data. So you need to be able to disaggregate it to understand where there are gaps and where improvements needed. So sometimes the biggest issue is the data isn't there in order to make informed evidence-led decisions. But this UN indicator framework helps give a sense of what's required in that respect. And so states in themselves have a degree of what's called like a margin of appreciation. So they have a degree of control over how they would like to demonstrate that evidence base and how they can subjectively show that they are achieving progressive realisation, but that as a legal concept has developed beyond the UN itself. So states that have introduced these types of rights in other countries have started to use ways of helping understand what that means in practice. And so the way it's understood in those countries in which there's more, so for example, as I mentioned earlier, South Africa's got quite an advanced post-apartheid constitution that better protects different types of rights, but there's a recognition that progressive achievement over time is required rather than an overnight change. So reasonableness is the way that it's assessed. So I mentioned earlier, you've got that concept of proportionality, and it's a similar type of test. There's an assessment of whether or not you can show that the change that has happened is reasonable in the circumstances. But ultimately, the most empowering human rights movements tend to be ones in which communities themselves start to gather the evidence, because it almost becomes impossible to. So, and by that I mean in relation to the rights themselves. So they will have a sense of being able to say why it's problematic in a way that perhaps an arm of the state hasn't fully appreciated before. So listening to communities about that evidence base is important. And when it comes to reporting to the UN, communities can also feed into what's called a parallel report. So the state does one, the government does a report, and then you have what's called a parallel report in which civil society can say when the UK is asked to respond on, for example, such and such a right, could you please let them know that it's not happening in practice for these reasons? And then that ends up in the state report. So we had a visit in 2018 from a UN Special Rapporteur called Philip Alston, and at the time he was UN Special Rapporteur on extreme poverty, and he did a visit to the UK, and he concluded that there were severe problems, and he called it an accountability gap as well with compliance with these types of rights. And what he said was that we had, by way of example, DWP, the Department of Work and Pensions, operates a policy called the Test and Learn policy. So when social security provision isn't operating properly, it says that it's okay, we'll try and fix it because we have this test and learn policy which is internal to our systems. And Philip Alston said, look, this is like a decade-long excuse and nothing's changed. It's not okay. The test and learn policy is not working, and social security is not operating as it should in order to meet the standards in international law. So it's in a sense, evidence gathering is more than the job of the state itself. Because sometimes it's about feeding into those processes to make sure an injustice which has actually been invisible becomes visible to more people.
Mm. So if one was minded to, how would one submit an entry for the parallel report?
So they run, the previous report for the Committee on Economic, Social and Cultural Rights, so every treaty has its own committee and they all run separate reporting procedures. I'm actually not sure when the next one is for the UN Convention of the Rights of the Child. I'd need to go and check the committee. So but that would be basically get in touch with the organisation that's been tasked with writing the parallel report. There's an incredible organisation called Together Scotland, which is an umbrella organisation for all child's rights organisations in Scotland, who are completely clued into the entire international framework and the domestic framework, and were part of the incorporation process. So they would most likely be involved in coordinating the parallel response from Scotland. So what happens now is you've got a UK parallel report by a civil society organisation, and then the devolved jurisdictions feed into that. And so it's normally coordinated within Scotland itself because Scotland's got a separate legal system. It's got separate things to report on, and the same with Northern Ireland and with Wales as well. And then that comes before the UN committee in terms of bringing light to the issues, and it's discussed at that level within the committee framework. The last one for the Economic, Social and Cultural Rights Committee was at the end of, I think, 2024, with reporting in 2025. So then the UN comes back with a report and with recommendations about closing some of those gaps. And it certainly draws global attention to things that can otherwise have gone, as often is the case with injustice. It's about making it visible.
So if anybody locally felt that there was an accountability gap, for example, between the local authority and the Scottish Government, and their voice was being ignored or left unheard, they could actually get it heard by the UN through the parallel report.
Yeah, and those parallel reports are really, really important accountability mechanisms. The committee also has what's called an optional protocol, which is a complaints mechanism. So that's like a quasi-judicial option, but the UK didn't sign up to the optional protocol for UNCRC. It has for other treaties, including the European Convention of Human Rights, of course, where you can take a case to Strasbourg if you haven't been able to secure a domestic remedy. But the UN Committee on the Rights of the Child optional protocol hasn't yet been signed by the UK.
Thank you. Is anybody in the room wanting to raise anything? Nobody's put their hand up yet. Yes, Emily.
I don't want to bring it necessarily back to specifics because I'm trying to be careful around that, but could the community, if they can evidence depopulation in a part of the island, and that depopulation has been systemic since certain decisions have been taken on the island, if they can produce that evidence of the depopulation of that area, and seeing as the Scottish Government referenced Depopulation in the Islands Act and how important it is to aim to reverse depopulation, with those two things in mind, if you could evidence that there was depopulation of an area, wouldn't it be I'd say a good idea for a local authority and the Scottish Government to take steps to reverse that depopulation, whether it be in siting of a new school? You see where I'm going with this, because we've talked about affordability, and affordability on its own seems not enough to say, well, we're not going to aim to reverse that. So they should be looking at various different steps they can take. They'd have to have a good reason not to want to do that if they had the power to make a difference to that systemic depopulation.
Yeah, so I won't speak about specifics that are connected to any proceedings. So I think if you think about, I actually don't know what the current legal requirements are around the existing policy, which has been quite recent, that's come out from, I mean, there's been lots happen, and this is not my field of expertise, but I am interested in following it because it's land reform in Scotland is a fascinating area if you're interested in looking at things like systemic injustice and historical injustice, and one of the things that's closely connected to that is a recognition that how important it is that areas which have been depopulated, that trend is reversed. And what I find frustrating about that is that there is quite clearly an acknowledgement that that is so important, and that is current government policy as far as I am aware, and very recent movements in that direction recognising that. We also have, for example, in the Scottish Parliament just now, a rurality inquiry, which is hearing about the provision of all these different types of rights in that context, and nearly all of the people who gave evidence in that are referring back to, because it's if you constantly remove local provision, whatever that may be, in the realisation of any of these rights, you end up with the area going into decline. So on the one hand, we have this recognition of how important that is, but we also have, for example, at the global level, what we now face in terms of planetary crises, we see an increase of recognition, particularly for children, about intergenerational rights and the rights of future generations, because we are crossing planetary boundaries. So a lot of that policy has been fed in from the international level in terms of the recognition of what's been faced. And a lot of the response is about, but we rely on our rural communities who are custodians of land and biodiversity to protect and continue to act in ways which help counteract that crisis. So you have this aim, you have these policies which all fall in behind that, and then simultaneously you have policies and provisions which go against that flow. And in a sense, that's related to historical legacies of how decisions were made, and made away from the way where people lived, and made away from the communities that, so you've got a lot going on there with things not only about population decline, but the destruction of cultural heritage, the custodianship of land, the reliance on people who live in communities to ensure, the response to a planetary crisis. So this is like, these two things are crashing against each other. So I see that in terms of how you watch these global trends, you see them filter down, and then there's just these cross-cutting issues. It's been going completely in opposite directions. And what's frustrating when you see that is in areas like the Highlands and Islands or in South West Mull, these are not peripheral regions. They have historically been, they're central. You know, they have, I play the fiddle, so I play fiddle music, and I know that the music that I play has been played all the way from Norway through Sweden, through Finland, through the north of Scotland, through the west coast, all the way down to Donegal, down to Dingle in Ireland. These are communities that have been interlinked for literally thousands of years through cultural heritage. So to think of them as outposts or peripheral is a new phenomenon. It's constructed, you know, it's constructed policies which depopulate. It's like wilderness. Wilderness didn't exist. It isn't a thing. It's de-peopled. It's dehistoried. It takes people away from their custodianship of their land, their culture, their heritage, and their community. And policies that do things like that, they cause fragmentation. You know, they cause fragmentation over time. So being able to demonstrate that, whether or not it can be linked into a human rights argument, is a separate thing. And that's not because it's not a human rights issue. It's just because the law is not perfect and we have to negotiate it around what we currently have domestically. But I see those trends and I see them as collective, social, cultural, historical injustice. And they require novel, ambitious, big thinking. If this is your aims and achievements, if these are your ambitions, if this is your commitment, find ways to fix it, to actually match the ambitions which reflect these global trends. You know, that's where you would hope responses are formulated.
Thank you.
I just wanted to quickly say that I attended a session, and it was an island session, and we were talking about depopulation, and the interesting thing that was there was that our council are working on different, and they're being sponsored to work on projects regarding depopulation, but what the islanders there present were saying was a lot of the data already exists, and if you work with us, you know, it's quite frustrating to see it, how things work in reality. So you've got these policies and you're spending a lot of money on depopulation, yet you're seeing decisions being made on the ground here that are causing possibly depopulation. So
I'm very conscious of time. We've got about 8 minutes left, so I'm going to try and I've got a question online which I want to try and take, but if you could just try and answer it just in 2-3 minutes, because there's a couple more I want to try and take.
Yes.
So the question from online is, what safeguards or governance mechanisms should be in place to ensure that consultation on school development is not merely procedural, but genuinely influences decision making in line with human rights standards? So, it's gone. I was going to repeat it.
I was going to say, go on one more time.
Can you repeat it?
What safeguards or governance mechanisms should be in place to ensure that consultation on school development is not merely procedural, but genuinely influences decision making in line with human rights standards?
Okay. So I'll answer that in the general sense of any decision making which engages with rights under the UNCRC or the Scotland Act or the Human Rights Act has to comply with those requirements I mentioned earlier. In relation to consultations, you have, for example, the Schools Consultation Act, which is an act of the Scottish Parliament, which is one of those acts which is within scope, where the UNCRC applies in its full, which includes Article 12 and the rights of the child to be heard and to have their views, to be able to express their views, as well as all of the other rights in relation to cultural life, education, family life, all fall into play when you have an act within scope, and that applies to all types of legislation that fall within scope of UNCRC. Under the Act itself, not only is there a requirement, or there an opportunity or a ability to raise proceedings in any court or tribunal if there's been a breach in relation to a public function under one of those ASPs. So that's really like seeking justice in any mechanism in that respect, but also under sections 11 and 12 of the UNCRC Act, both the Scottish Human Rights Commission and the Children's Commissioner have the power to raise or intervene in proceedings as well. So there's several mechanisms that are supposed to kick into place in addition to the requirement to report on how you're, to demonstrate how you're meeting obligations.
Thank you. The questions are coming in thick and fast online now, so just a couple of minutes to try and answer this one. And this sounds like somebody who's quite frustrated. And don't take it away yet, Joe. If one gets no joy from appeals to obvious duty bearers regarding the UNCRC related matter, is it realistic to escalate the issue in question to the most senior figures of that authority, be it the chair, the CEO, the First Minister, or the Prime Minister? So if one gets no joy from appeals to obvious duty bearers on a UNCRC related matter, is it realistic to escalate the issue to the boss?
So I think, one of our rights as citizens is to address those that are our representatives in both Parliament, and that includes the UK Parliament and the Scottish Parliament. In relation to duty bearers, under most of our domestic law, you do have multiple duty bearers which operate concurrently. So whilst often it will fall to the body that has a statutory obligation to be the first port of call, and whatever appeal mechanism they have, either through legislation or within their own within their own institutional infrastructure, it would be most helpful, I think, to make all the other duty bearers aware if in particular you've not been able to get recourse to a remedy, which includes a detailed response to explain how decisions have been made.
Okay, I suspect that the First Minister or the Prime Minister would just refer back to the person who's been not giving the responses.
Or they may refer to the relevant department, because so much is, the statutory frameworks are complicated, and there are, different responsibilities at different levels. But it is helpful. Ultimately, I talked about that multi-institutional governance and multi-institutional accountability. The Scottish Parliament has responsibility to hold the government to account, and the government includes all public administration. The executive is like all the way down, so the Parliament has responsibility for overseeing that, and so there, each of those mechanisms all the way up to the top have at the very least should have awareness of ongoing injustices or issues, and hopefully be given the opportunity, and ultimately this person or body that has a statutory obligation should include those other duty bearers or invite them in to try and find local solutions if it's not possible to meet statutory obligations by way of example without that multi-institutional response.
Thank you. And what I think is going to be the final question, again, is online. From a children's rights perspective, is there a distinction between a temporary delay and an indefinite delay in delivering school infrastructure?
Again, I'll speak about rights realisation in a general sense. So in relation to any economic, social and cultural right, you have what I mentioned, those progressive realisations, which also include a minimum standard, a minimum expectation, or what's called the minimum core. Where there's delay, it must only be temporary, and it needs to be justified. So you've still got to meet those legality, legitimacy, proportionality requirements. There shouldn't be any discrimination. You've still got to meet the steps that are the resources that are deployed are effective, efficient, adequate and equitable. So temporary delay is only allowed in very slim circumstances. And ultimately, some rights have a higher threshold than others. So in particular, if you look at children's rights and the right to private and family life, that is a very high threshold to cross in order to demonstrate that your response has been proportionate, legitimate, necessary, not arbitrary, and no other alternatives were available.
Very interesting. Right to family life. So we've got that question answered. I've got one final question online, and it's a yes/no answer. Is the Lundy model expected to be used by public authorities? In other words, should the Lundy model be used by public authorities?
So in relation to yes. Yes.
Thank you. And
it may be a very
10
quick
seconds.
very quick answer, and it probably is a similar answer to the question we asked earlier about affordability. But I just want to know whether geography and environmental impacts can be used as a justification for ignoring the UN rights of the child. So, where you've done a transport impact and it might increase transport hours, is that acceptable to justify ignoring, again, the UN rights of the child?
Or interfering, I think is the phrase. Interfering with those rights.
So I'll respond in a general sense around balancing of rights. You would normally expect a very high threshold for interfering with some rights, and it would depend on the circumstances about what you were weighing up. So it is a legitimate aim to, for example, to have environmental goals in mind, but the threshold for passing that you would expect to be significant in comparison to other alternatives, weighed up in the circumstances fully. But what you see often now in terms of litigation globally is children's rights and future generations and intergenerational rights. Environmental concerns are very much part of that, but not at the expense of children flourishing in their environment and meeting their developmental needs. And there is a provision in Scottish law, in the Standards of Schools Act, that says that there's an obligation to meet the developmental needs of every child to their fullest potential, and that provision is within scope of the UNCRC, which brings in, like the full treaty provisions around that, including family life, including education, including housing provision. All of that is caught by an act of the Scottish Parliament, which actually directly mirrors the treaty. It uses the same words. So the section 1 and 2 of the Standard School Scotland Act uses the exact same words as the treaty. So there's a clear indication by the Scottish Parliament, even before the UNCRC Act was applied, they expected this standard to apply in law in relation to, for example, the right to education.
Thank you.
Wow. I think we need to draw proceedings to a close, and I just want to say how very impressed I've been with the depth of knowledge that you've got on the subject. It's pretty inspiring, to be honest, and I think it's given many of us in the room and hopefully online food for thought. If anybody wanted to learn more, to find out more, to get advice on particularly the rights of the child, I think your crib sheet is going to be, it's actually crib sheets, you'll not be surprised to know, but there is quite a detailed crib sheet which will be available after the meeting. But I'm just wondering if there's anywhere that, if there are any politicians I know there are some politicians online, there may be civil servants who are listening to this. Is there a source of advice and information that's available for those people?
So the Scottish Government has guidance on how to comply with UNCRC. They have guidance that is hosted on the websites of the Children's Commissioner, which is the statutory body responsible for implementation of UNCRC and helping to provide information around that as the Children's Commissioner, or Children, I think it's Scottish Children's Commissioner for Young People, I can't remember the exact acronym. And then you also have Together Scotland, which is, as I say, the umbrella organisation, which is absolutely fantastic and has it all broken down and has material for children themselves to help and, you know, work along children understanding their own rights.
So is that the Commissioner for Children and Young
That's the
People
one.
for Scotland?
That's the one.
Whoa.
That's the one. Thank you.
Yeah, I'd like everybody to just put their hands together and thank Katie for coming all the way to Mull this evening and for giving us such an informative discussion. Thank you.
Thank you.
Good.
Cut, turn them off. Bye bye.